Okay, this is just a recap of the slide. There are three categories of bills of lading. Nominate means to whose name the bill of lading is addressed, and only that person who will come on the discharge port to the carrier's agent, prove his identity that my name is there on this original set of bill of lading and this is my identity. So the agent issues a release order of the cargo and he informs the mark. Then there is an order bill of lading that whosoever is holding the original bill of lading is entitled to take the delivery of the cargo. And this is where the issue of document of title comes, which is very common in bulk carrier trade and tanker trade, that between the load port and discharge port, the title has changed a number of times. The bottom line is whosoever is holding the original bill of lading, the cargo has to be discharged to him. It is like the bearer bond, like a self check. And bearer bill of lading is also, sorry, order is can take, and normally as we will be doing, order is sometime order to bank, which will become all the more clear when I'm doing the documentary credit system. And that bearer bill of lading is whosoever is the holder of the bill of lading can take the delivery of cargo. But we will come to these categories later on. Then there is negotiable bill of lading and the non-negotiable bill of lading. This is like negotiable bill of lading comes in the category of bearer bill of lading that is provided to make the delivery of goods to anyone having possession of original bill. So the bottom line comes is having in possession original set of bill of lading. If you don't have that, well, you hang yourself upside down, the cargo will not be delivered to you. An original BL at the discharge port. Then this is negotiable. Negotiate. What is being negotiated? The document of title. The title is being negotiated. And very rarely will you see this kind of bill of lading on board. Most of the time you will see as the watermark in a diagonal said non-negotiable, which means that the specific name of the consignee, the specific name of the receiver of goods will be mentioned in the bill of lading. And the important point is our job on the ship is whom to deliver the cargo, whether that guy who is receiving the cargo is the owner of the goods, he has got the property rights, we have got nothing to do with it. This is a non-negotiable bill of lading. That guy's name is there on the bill of lading. He has proved his identity. We are authorized to deliver the cargo. And 99% of the bills of lading that you will come across will be non-negotiable bill of lading. But we need to go a little bit in detail with the concept of the types of bills of lading. Where, and believe me, in your answer, you will write it strictly in that order as a receipt of goods. It's a document of title and it is an evidence of the contract because it also indicates yours and my involvement on board the ship. We have the maximum involvement with regard to the receipt function of the bill of lading. We have got a very limited involvement with regard to the document of title bill of lading, whom to deliver the cargo. And you and I on the ship have got no involvement with regard to as evidence that it is a contract of carriage, because the contract of carriage has taken beforehand between the shipper of goods and the carrier. So Being a receipt, BL contains description of applicable goods in the margin or as an attachment. It is so important a thing that even a single package is damaged, you are not supposed to receive the goods. And as we will see when we are doing the letter of credit system, why the shipper jumps and begs the agent or the master, please do not mention the damage in the goods. I will issue a letter of indemnity. Please sign it as a clean bill of lading. The bottom line is letter of indemnity that, okay, so and so good is being loaded in a damaged condition. Letter of indemnity is not sufficient because letter of indemnity only takes care of the damage caused to a particular parcel. Letter of indemnity does not take care of the carrier's responsibilities and liabilities with regard to safe carriage. Even if there is a letter of indemnity that the damaged box that has been loaded, the shipper will pay the receiver of goods. The receiver of goods can still, within the 1 year or after that, as agreed upon, can take the carrier to the court claiming for compensatory damages. Well, what about your responsibility? You are not supposed to load the cargo in a damaged condition. Number two, the important point is the receiver of cargo has got no possibility to inspect the cargo before it is being loaded. What is the prima facie, on the face of it, the evidence in the hands of the receiver of cargo regarding the condition of goods? And that is the description of goods in the bill of lading which has been signed by the carrier. So if there is no remark put in the no remark put in the bill of lading, it's a clean bill of lading. That way, the description of goods, so many packages, so many, this a type of cargo, etc. I am going to be receiving this. I will have an arrangement with the wholesaler based on that. And when the goods which are being discharged in a damaged condition, what is he supposed to do? He has got every right to take the carrier to court. I based my business of selling it into the market because you signed a clean bill of lading which indicated there was no damage to cargo. And now you are discharging the cargo in the damaged condition. The carrier said, well, your shipper in the load port has given this letter of indemnity. Yes, that will take care of this particular package, but what about your responsibility? Because, or based on your responsibility of signing a clean bill of lading, I arranged the sale of goods into the market. Now that has got jeopardized. I'll take you to court. Are you understanding the difference and the problem associated with a letter of indemnity? Are you with me till here or not?
Yes, sir.
So, in such a case, what you're supposed to do? Well, hang on. If you're not allowing me, if the master tells the shipper, if you're not allowing me to put the remark, hang on. Immediately, master is supposed to call the P&I club representative. Let him advise. As we have said, P&I club is on your side. Bill of lading is an acknowledgement of the receipt or the goods specified therein. Based on this, the receiver of goods in the discharge port is executing his business. That is the most important thing. It is just so. as a mate, your biggest responsibility is in a dry cargo, break bulk cargo where there are different consignments, that not a single packet is damaged. It's a very big responsibility because the master is going to rely on your report that, okay, goods are loaded in good order and condition, because that is what he's going to tell the agent. Majority of the time, the bill of lading is made and signed by the carrier's agent, and two sets are couriered, given it to the shipper, who couriers it to the receiver of cargo at the discharge port. Having What is the difference between prima facie and conclusive evidence? Prima facie is on the face of it. Conclusive is when the shipper is giving it in writing that out of 100 packages, 10 of the packets are being loaded in a damaged condition. Not a letter of indemnity. He is actually giving it in writing. That is a conclusive evidence. That is a separate thing. That he has informed the carrier in his contract of carriage that too bad, this has got damaged. I've got an arrangement with the receiver of the cargo. Out of these 100 packages, I am having 10 packages loaded in a damaged condition. That is a conclusive evidence. Prima facie is when the receiver of goods receives a clean bill of lading, he, on the face of it, that goods that are going to be delivered to me are going to be in good order and condition. So that is the most important part, is your job as a mate, and that is what you will be writing in your answer. Second, the document of title. Why it is called a key? Key to what? Receiving the goods. The goods are in the lock on the ship. I, the receiver, has to open that lock on the ship, and to get the cargo out, I require the key for that lock. That key to that lock is that bill of lading. And depending upon the type of bill of lading, it is the person who is holding the original set of bill of lading is what is the justifiable receiver of the cargo. Evidence of contract, I have already spoken a lot on this part of it. And now what I want to come in, the types of bill of lading, a common question. I will not go too much into detail because this you'll have to read, and some part the title you have to memorize. But there are two categories. In each of the category, they are different for each bills of lading. A, how it is executed, and what is the mode of operation. On the basis of execution, it's a straight bill of lading, open bill of lading, bearer bill of lading, order bill of lading. Let's briefly touch upon this. Straight bill of lading reveals that the goods are consigned to a specified person. Bill of lading made out to named consignee without adding the word to order. Bill is non-negotiable without adding. So let me add it here without, and we put it this, non-transferable, or we can say non, because that is the word we have been used. It cannot be transferred. Bill of lading made out to order or to a named party with to order are known as order bill of lading, transferable and accepted as document of title. This is where to order the bank, where loan from the bank has been taken to pay for the goods. Open bill of lading. This is a negotiable bill of lading where the name of the consignee can be changed with the consignee signature and thus transferred, which we call he endorses it. On the reverse, there is, okay, I am transferring the title of the for receiving this goods to Messrs. So and so, whose identity is this. So at the discharge port, he comes with the identity. Then the third type is bearer bill of lading, which is a very common thing in case of bulk cargo and tanker trade. Order bill of lading expresses word to make the bill negotiable, means delivery is to be made to further order to the consigning using the word delivery to A Limited or to order or to assign. It is always endorsed. These are the few terms that you will have to go through and memorize. All the details are there. By the way, February batch, I've only just checked my mail today that I have received your consolidated emails within a day or two. Most probably by tomorrow, you will have everything. Order bill of lading, the most modern type of bill, which is widely used all over, ensures safety of delivery of cargo to a genuine holder of the bill of lading. Now, coming to the other kind is what to order back. I'll come back to this when I've done the letter of credit. Method of operation. Shipped, received for shipment bill of lading when the carrier has taken responsibility of the cargo while the cargo is in the warehouse at the load port because his ship has got delayed. Received for shipment, the agent will issue. Responsibility of the carrier will start there. Shipped bill of lading, let's put this in red because this is where you and I come into play. We on board the ship are concerned with shipped bill of lading. A clean bill of lading means there are no remarks for the damage to the cargo. It is the dirty, or it is sometimes also called claused, C-L-A-U-S-E-D, claused bill of lading. Dirty or claused bill of lading is when a remark by the ship has been put, we don't care. Our P&I club has said 10 packages marked so and so loaded in damaged condition. And why? The shipper of goods actually holds the feet of the master. Please do not add this because the receiver of cargo will not be able to get a loan from the bank to pay the seller of goods in the load port. Therefore, he is going to say, well, to hell with you and your contract which I have had, I am not going to receive the cargo. So this is what we are going to go through. Bill of lading and combined transport bill of lading are more and less the same in the sense they're named differently because combined transport bill of lading is more to do with multimodal transportation, door to door, which we do more in detail at the ASM level. Through bill of lading is a single bill of lading is issued that the cargo is picked up from Delhi, taken by trade by a truck trailer to the container terminal, from there by a goods train to Mumbai. Mumbai, it is loaded on the ship and taken to Antwerp by ship, offloaded, and there it is taken to Brussels by a truck trailer. It a single bill of lading through and through, meaning the entire responsibility is that of the carrier. Are you with me? Meets receipt, as the name says, this is where you and the mate comes in to play directly. And every shipment, every loading does not require this. You may not have seen it, but what happens is a number of times from start to finish, the bill of lading is going to be prepared by the agent in the load port after the ship has sailed. So in order to issue the shipped bill of lading to the shipper, the ship's agent will require the details of the cargo which have been loaded, which have been shipped. Only in those circumstances, the agent comes directly to the chief officer. He tells the captain will tell you that, okay, the agent will be coming for the mate's receipt, just sign it as per the thing, and there will be a huge bunch because that is what he's going to prepare prepare your what do you call bill of lading on that, and that is supposed to contain the detail of every package. If there are 100 packages, there will be 100 bill of lading, 100 baits received. If there are 10,000, there will be 10,000 of them. He'll give you time for that. And these days, mate's receipt is also called standard shipping note. The information filled by the agent in the shipped bill of lading has to be identical to the information of the goods loaded in the mate's receipt. And if there are goods which have been loaded in a damaged condition, well, you have to mention that in the bill of lading. Thereafter, your job is done to put it on the bill of lading as a damaged thing. That is the headache of the agent, and you will make a logbook entry to that. The most important point for you is, what is the format of the mate's receipt? It is an internal document of the ship, internal document of the carrier. So therefore, there is never a fixed format. It is the format of the carrier, the ship owner, the shipping company, which the agent has. So you may say, okay, last company, the format of the mates received, I remember, was different. Well, this is different. Well, each owner can have a different format. That is the mate's receipt. The focus of it is to be signed by the mate of the ship, giving details of the cargo that has been loaded, which includes the condition of the cargo. Now, you will be surprised, people, what is a seaway bill? People call it as seaway space bill. That is the biggest mistake that people make. It is a way bill. There are different categories of way bill: road way bill, air way bill, sea way bill. Okay. Sea way bill is always issued, if at all, it is being issued, it is in lieu of the bill of lading. So what are the circumstances? We know that bill of lading has got three functions. One, receipt of goods. Two, document of title. Three, evidence of contract of carriage. A seaway bill has only two functions. That is receipt of goods and evidence of contract of carriage. It does not cater to the element of document of title. That means there is no possibility of what do you call changing hands as to who is going to be receiving the cargo at the discharge port. So the question comes, under what circumstances will the shipper of goods in the load port would want to use a seaway bill instead of a bill of lading and avoid all the hassles, etc., when the shipper of goods is 100% sure of the person. Right? The whole idea is what? Let's come down to the basic. A ship, the bill of lading has been issued, couriered in original to the receiver of cargo at the discharge port. Based on that, okay, this is the goods I'm going to be received, which I have contracted the seller, against which I am supposed to make him the payment. The ship discharges the cargo, everything fine. Mr. Shipper, Mr. Loader of cargo, here is your payment. Here is your payment. Just a sec. Now, what happens is, if one of you is the receiver of goods at the discharge port and I am the loader, shipper of goods at the load port, you are my relative and I have been doing, you are my business partner. I have been doing business with you for 10 years. I have 100% trust with you. Ki once you receive the goods, my money is 100% safe. You will give me the money for the goods that I have sold to you, which I have put on the ship, and you will be receiving. तब फिर document of title की क्या जरूरत? I know you, yeah. In that case, you and I will agree. Yeah, I'll just tell the carrier to give me a seaway bill. पैसा तो दो ही दोगे. So the biggest difference between bill of lading and a seaway bill is bill of lading. The person who is entitled to receive the goods at the discharge port does not have the property right. We don't deal with it. He's just receiving the goods. Whether he is entitled to sell the goods in the market, etc., that is between the buyer and the seller. We don't do it. He only has the power to receive the goods, but he does not have the powers to sell it. In a seaway bill, since the concept of document of title has been removed, the person who's entitled to receive the goods can even sell the goods, and it is entirely up to me. As far as to mera paisa de rahe ho, I'm 100% confirmed you have got the property rights also. I release the ownership to you to sell the goods, and we are business partners. Its only difference is I am physically sitting in the load port, you are physically sitting in the discharge port. Well, I have that complete trust in you. Only in those circumstances will a seaway bill be issued, because it only has two functions. Seaway bill only plays as an evidential function and does not give the title to the goods, because the title is not important. The title is not important. The fact that I'm having the seaway bill, I can receive the goods. So that is what is the biggest difference, that in a bill of lading, there are three functions. Seaway bill, there are only two functions, as the receipt of goods and evidence that, okay, I have contracted this carrier to carry my cargo. Seaway bill is issued when the shipper, that at the load port, knows the receiver of cargo. And shipper is under no doubt about his payment from the receiver of cargo. I'll issue a seaway bill. Are you with me?
Yes, sir.
Yes, sir.
The biggest letter of indemnity is a document given by the party for doing something which is not correct. I'll not say not correct, which is not a normal practice, deviating from the normal practice. What is the common thing? Oh, captain, don't this, it has started this thing. Don't stop the cargo work. I'll give a letter of indemnity for any damage that happened if that cargo gets partly damaged because it gets wet because of slight drizzle. Take a walk, yeah, what about my responsibility? The biggest thing that letter of indemnity assigns there is a right to recover from the issuer of the letter of indemnity. Popular scenarios when LOI is issued, and when you should always treat it with suspicion. Why? After issuing the letter of indemnity at a load port, the cargo is loaded, the ship departs, the person issuing the letter of indemnity runs away. Everything comes on the carrier. You have to be very, very careful. Release of cargo without original bill of lading. By law, that is wrong. Release of cargo against a lost bill of lading. Legally, that is wrong. Delivering cargo at a port other than what is mentioned in the bill of lading. Illegally, wrong. Issuing of clean bill of lading when the cargo has been loaded in a damaged condition. Issuing a backdated or front-dated bill of lading. Requesting carrier to carry on with cargo operation when raiding. You are not going to undertake that because the biggest important thing is all of these are third-party damages, and if anything against the letter of indemnity comes on the carrier, the P&I club comes into play. They do not entertain a letter of indemnity. They said this is against the contract that you, the membership owner, has entered with our P&I club. You will have to take care of it on your own. This is a non-contractual risk. We don't cover it. So that is the reason it is treated as a documentary fraud by most of the P&I club. Never do anything against a letter of indemnity without consulting your P&I club representative in the load port. The risk is also important because the letter of indemnity is only as good as the person signing it, and in cases where claims happen a few years down, that guy is no longer available. Tab kaun karega? And the most important aspect is the most important, if I hope I have written it, it does not relieve the carrier of his responsibility and liability. मान लीजिए you are the carrier, master and mate of the ship, representing the carrier. I am a shipper of goods in the load port. One packet has come broken. It is being loaded. You tell the captain, sir, I have stopped the cargo because one cargo has come loaded. Captain calls the agent. I come in front. Captain, don't worry. I'll give a letter of indemnity. Whatever claim by the receiver of cargo in the discharge port because of this damage that has happened, the letter of indemnity indicates that I will be paying him. You don't have to bother about it. It is only talking about the damage. But what does the law say? Mr. Carrier, being represented by the master and mate, what about your liability and responsibility for loading the correct cargo and mentioning it correctly in the bill of lading? Letter of indemnity does not take care of that. The guy receiving the cargo, ठीक है, मुझे तो पैसा मिल गया because it is damaged, but what about your responsibility? I'm taking you to court. You acted irresponsibly. It does not relieve the carrier for the responsibility and liability for loading the cargo correctly and mentioning the correct state of the cargo that is shipped before signing the bill of lading. Have you understood the biggest importance that why the cargo loading or discharging of cargo against the letter of indemnity, you have it tattooed here? No, I'm not taking care of it without the advice from my P&I club.